and I'm an attorney with the law firm of Turner Zamarripa, Attorneys at Law here in Pueblo. What we will be focusing on today is we will be focusing on evidence admission in court of law. So if you are representing yourself, the judges will still require that you admit evidence and you act in accordance of what you usually would or what a lawyer would expect you to do. Well, many of us had to go to law school for at least 3 years to be able to do this. So this is going to be kind of a crash course in some evidence information. We have some handouts that I will make available to the self-help center so that they have them available, but we'll talk about a basic analysis of what you have to have in order to admit evidence and how you have to present it. As a preliminary issue of what we have to have here and what we're discussing is if you are actually in physical court with the judges, and some of the judges are still requiring in-person physical court, you will be expected to have at least 3 copies of every piece of evidence that you want to admit. If you want a video, you're going to have to come in with 3 jump drives or 3 discs where those videos are on. If they're photographs, you're going to have a packet of at least 3 sets of those photographs. The reason that you need at least 3 is you'll have to give one physically to the court and to the judge so that the judge can review that and look at what you have what they have in front of them and what you're referring to. You are required to give a packet of whatever you're referring to your opposing party. So whether it's another attorney or another individual who's there representing themselves, you have to give that packet to the other side as well. The third packet is for the witness stand. So the person who will be testifying about those documents will have to have it physically in front of them at the witness stand. And we'll talk about some of the phrases in terms of art that you need to admit each one of those types of okay. And this is what we'll be discussing. This talks about the general rules of evidence. Looking at all of our rules of evidence are covered in the Colorado Rules of Evidence, commonly referred to as CRE. Luckily for Colorado, if you ever start to do a Google search for certain rules of evidence, Colorado's rules of evidence and the federal rules of evidence, the FRE, are very similar and they match each other in many ways. But one of the things that you're going to be looking at as far as applicability, you're going to be looking at Colorado Rules of Evidence 101, which apply to say that the rules of evidence apply to every court in Colorado and in every case. Colorado Rule of Evidence 1101AB gives some general applicability for civil cases, criminal cases, and contempt cases. So you'll want to start there to look at what rules will be applicable to the specific type of case that you have. And what we're doing today, for the most part, is that we're just covering general rules of evidence and general admissions of items that are out there. If you ever want to review the actual rules of evidence, they are found in the Colorado Revised Statutes 13, 25, 101, and they go all through 1390, 101. So there are quite a few there, and we'll talk about some of the handouts that we have. Some of the things that you definitely have to keep in mind that we want to talk about if you're dealing with any type of custody case, protection order cases, or things along those lines. Witnesses must be present to testify and to say the things that they want to say, because people have a right to cross-examine them. So if you are a litigant in a divorce or a custody case or things along those lines, you can't come in and say, my kid told me, or some other kid, grandma says, my granddaughter told me. None of that will come in, because that's what's called hearsay. And so what you're going to want to look at for hearsay, because this happens all the time that we have in court cases, is people want to talk about what a child told them. In order to look at child hearsay, you have to have a hearing about that child hearsay before it goes to court. And you're going to be looking at a very specific statute on child hearsay, which is Colorado Rules of revised statutes 1325-129. Overall, it looks at certain times that a statement, out of court statement of the child can come in. Now, one of the things I want to address as well as we're looking at this is looking at the summary guide. That, in all honesty, some lawyers and plenty of judges don't understand how to apply the rules of evidence regarding hearsay. But the definition of hearsay is it is an out-of-court statement. So statement has to be words. That it's an out-of-court statement, either oral or a written assertion. It can be nonverbal conduct if it's intended to assert and make an assertion. So if somebody's nodding their head yes, that's a statement. The declarant is the person who made the statement. And so hearsay is defined as any statement other than by the declarant while testifying at trial offered to prove the truth of the matter asserted. It's very kind of difficult to determine what you're trying to get of the truth of the matter asserted. When you're saying somebody said something and what they said is true, that is by definition hearsay. So if a cop comes in and says, the witness told me that they saw the red car run the red light, that's hearsay. You're not allowed to admit that into court. You have to have the person, the witness, come in and say, I saw the red car run the red light, because you don't have an appropriate exception to the hearsay rules to admit those. I'm starting here with hearsay just because it is one of the most complicated and one of the most difficult rules of evidence, and it's the one that in many ways certain statements can come in when they're being asserted for not the truth. You're not saying that what this person said is true, but the different ways to have it come in. So if it's a statement by the other side, if it's the person who is the what we call party opponent, their statements come in. Anything that they say would come in. It's not considered hearsay for their statements to come in. You also have some of these objections that you have, and they're very particular. Spontaneous present sense impression, talking about describing or explaining an event while it's happening. Very rare that we see those. Excited utterances, so statements related to a startling event or condition while made while the declarant is under the stress of the startling event. Some then existing physical or emotional conditions. I felt or I feel this. You can bring in statements for medical diagnosis or treatment. The idea about some of these hearsay exceptions is that their statements are so reliable, you wouldn't question the veracity of them. Recorded recollections, some of these other ones, but one of the things where we really get into some hearsay exceptions that we're saying we're not using the statement for the truth of the matter asserted. And so we're using the statement to say this is why the person who heard this statement did this. And this is one of the ways that certain things come in is if a child says, so-and-so hit me. You can't bring in the statement that it's true that somebody hit that child, but you can say, this child told me that they were hit, so that's why I called the cops. That's why I did this. So the effect on the listener is one of them that's very important and helpful to use when you're looking at the hearsay rules. Go back over our outline. For some of the child hearsay issues, and in the outline as well to be provided to the court, we'll have some methods to avoid or mitigate some of that testimony. Let's see. Stop sharing my screen here for a second, because one of the things we'll actually talk a little bit more about, I did that wrong, is the general rules of evidence have general provisions that you have to come in to be able to bring in information. The first statement that you need to ask yourself about any piece of evidence, whether it's a statement, whether it's testimony, whether it's pictures, text messages, videos, is it relevant? If the court doesn't feel that it's relevant to the present proceedings, the court cannot admit the evidence. Relevant evidence is evidence that is tending to make a fact of consequence more or less probable. One of the things that you'll find across the board in hearings regarding child custody, usually, or changing some of that child custody, the courts do not find as relevant anything that happened prior to the last modification of the child custody. So you don't get to come in and bring in relevant factors that you think are relevant for something that happened 10 years ago, and your most recent modification on the custody was 3 years ago, because the court believes that everything that was relevant 3 years ago was brought to the court's attention, and whatever previous court usually ruled had all that information. And so you don't get to bring it up at a later date. So your relevant timeline is usually going to be the last time that you litigated something, particularly when you're talking about family law cases. Character evidence is another one of the pieces that come in our chapter 4 of our rules of evidence, which we deal with a lot. You cannot bring in character evidence to say they did something bad before, they might do something bad again. That's what we call propensity. You're not allowed to use evidence of that, but you can, in certain instances, use prior bad acts or prior conduct, but they have to be admitted for a specific purpose, and it can't just be to say that person was bad, so they're going to continue being bad. It has to come in as you can start to see some of the basis of why it can come in as what we call the 404B evidence. And under 404B, it can come in as proof of motive, so why that individual did what they did. Opportunity, that they made a statement or had an action that gave them an opportunity to do something. It can be their intent or their plan. So you can use the prior acts to show this intent or this plan. You can use some of those prior acts to show that they knew something existed. You can use prior incidents to prove identity, but in most civil cases and pro se cases, you're not going to have that very often. You can often use it for what's called absence of mistake or accident, that they have done these kind of things before, and so for them to say that they did something similar this time, that was an accident or a mistake, you can say, no, they already knew previously that this was not okay. So those are the few times that you can bring in character evidence and specific conduct that can come in. And routine often does not come in. It's not used to show that you did something. Usually it's only admissible to show the conduct of a person or organization. Let's see. Regarding witness credibility, there's specific rules of evidence in the 600s, chapter 6, that talk about credibility. Credibility under 608 of a witness may be supported or attacked by character evidence, which is reputation or opinion only, not specific conduct. But that evidence may refer only to the character for untruthfulness or truthfulness. The evidence of truthful character is admissible only after character for truthfulness is first attacked. So you don't get to go into characters of witnesses very often. The very few times you get to get into what's called specific instances of conduct to support their character for truthfulness is also very rare, unless you're talking about felony convictions or certain convictions that they might have that go to truthfulness. So perjury, theft is not a character for truthfulness crime, so we can't say that they'd stolen something before, so that's a character regarding their trait regarding their truthfulness. You're not allowed to use that. As far as some of the foundation pieces that you will get into, we'll talk about the we have to admit. But so what you're going to have to admit exhibits is you have to have what's called a proper foundation and authentication. You need to be able to have someone testify that this document, this photograph, this text message, whatever it is what it's purported to be. And that can be you as the individual. If you have the text message saying, Judge, here's the copy of the text messages. I received these from John Doe on this day at this time. I know that they're the text messages that I received from him because you can see up here, here's his name. If you look at the contacts in my phone, it says this phone number. And so you have to have that foundation saying that somebody has personal knowledge of what they're admitting. So the first step in that, with that foundation and authentication, is the relevance. Is this item relevant for the court to hear regarding the issue in front of it at that point in time? Then the authentication, that it is a true and accurate representation of what's trying to be admitted. The person admitting it has to have personal knowledge. One of the things that you'll see with cases, people seem to think sometimes, or frankly, young baby lawyers seem to think that you need the person that took the picture. If you're admitting a picture, you don't. You need the person that can say they saw this person on this day, the same day that that picture was taken, and this is what the injuries look like, or this is what the house looked like, this is what the person looked like. So somebody has to have personal knowledge of what's in that exhibit. Sometimes you'll have to look at, see if there's a privilege there. Attorney-client privilege, doctor-patient privileges. Most likely your privileges are not going to attach as you're admitting the exhibits and the items. But you're going to run into the fact that is any of this hearsay, because if you're admitting a document, you have to have a hearsay exception to why the statements in the document come in. It's one of the main reasons that police reports are not automatically admissible. Police reports that an officer came out and interviewed somebody and they said this, this, and this, those are not admissible in a court of law to say this is what the officer did and this is what the person said to the officer. That is the textbook definition of hearsay. What you have to have instead of the police report is you have to have the police officer who says, I talked to so-and-so and so-and-so saw this, this, and this. You need to have that person who said, I saw this and this is what I told the officer. So you cannot just admit a police report. Things that you might think would be just normal documents held aren't automatically going to come in because you will have to have an exception to the hearsay rule if there's any statements that are made in there. A letter from a doctor's office is probably not going to automatically come in unless the doctor is making a statement regarding treatment or diagnosis. Because the doctor has to be available for cross-examination on what they put in their letter. So you need to make sure that you're going through with any of your exhibits as you're doing it, is there an exception to the hearsay rules? And then you want to make sure as much as you can that what you're admitting is the original document. It can't be altered, it can't be changed. One of the things that we will see a lot of times in court is individuals will try and admit text messages between the two parties. Well, those are going to come in because they're statements by both of the parties, but they don't have every text message. So if you don't have a complete original tracking of the text message, that message and that exhibit itself may not come in at all, because you'll need to be able to authenticate how it's a true and accurate representation of this complete conversation. So when you're taking pictures and screenshots of text messages, I advise all of my clients that they take a picture, the screenshot of the text message, and whatever the bottom line is on that message, you start with that message on the next screen so that you can ensure that they're following along and you know exactly which screen goes after the next screen so that you can follow the full conversation and admit it in that when you've got your 4 sets in front of you. With us being in COVID, and a lot of our courts are doing virtual WebEx courts and things like that, you will be required to submit your exhibits to the court usually 7 days in advance of your hearing. So they have drop boxes at Judicial that you can come in and you drop a stack of your exhibits. But the things that you need to know about that is you need to have a cover sheet with it that has the case name, the case number. All of your exhibits have to be numbered or lettered depending on what you are. That's a good time to mention that if you are the petitioner, the person who started the case, if you're the petitioner or the plaintiff in any one of those cases, your Exhibits will be by numbers, 1, 2, 3, 4, 5. If you are the defendant or the respondent, so you're the person who was served with the paperwork in the original case, then your exhibits will be done by letters, A, B, C, D, E. If you're an intervener or a third party, then you'll put your type of status on there. And I usually use numbers. So I'm a child legal representative. And when I admit exhibits as the CLR, my exhibits are numbered CLR 1, CLR 2, for the judge to be able to follow. One of the very important things to keep in mind on that when you're doing that is that all of your things are clearly marked and noted, because in the event that either you win or you lose, depending on what type of case you have, the entire ruling is appealable to the Court of Appeals. In it, the actual record. It's what we call a cold record. They'll be able to see the transcripts, but they don't hear the recordings of people being passionately talking about things. They don't get to see a video or anything that happened. They get somebody transcribing words on a piece of paper. So you'll see judges make sure that you're close to the microphone when you're presenting evidence. And so all of your exhibits need to be clearly marked so that an appellate court, as well as the judge that you're in front of, can follow it and know what number you're talking about. One of the things that I do just to make my records clear is every single time somebody holds something, I don't say, and you're holding that. I'll say, you have in your hand what's been marked as exhibit number 5. What is exhibit 5? Not what's that. How do you know that exhibit 5 is a set of text messages? There's your personal knowledge that we were talking about. Is exhibit 5 a fair and accurate representation of the conversation that you had with Mr. Smith on December 7th, 2020? Yes, it is. Your Honor, move to admit exhibit number 5. So you always title it what it is, exhibit 5, exhibit this, so that it's pretty easy to follow. But once you've gone through with your exhibits here, your proper foundation and authentication, that's how you ask the court to do something with it. Your Honor, I move to admit exhibit blank. Here is another very, very important thing to keep in mind as you're doing this. Unless you admit the exhibit and you have somebody testify to its authenticity and it's actually admitted as an exhibit, the court cannot and will not consider it. So if you upload 20 exhibits and you get up there as a pro se party and you just say, I want to be divorced and I want this and here's what I want in the divorce and here's why I want maintenance and here's why I want this piece of property. Here's the things that I think the court should do, but you don't admit any of those 20 exhibits, the court's not allowed to consider those 20 exhibits. So you need to make sure, and I keep a checklist, very literally a checklist that I have that says what my exhibit name, number or letter is, what it is, and then I check off when it gets admitted. So you say, I move to admit, and the court says yes. No one, not you, not a witness, not the court, not the other party, no one can testify about what's in an exhibit or what it is until it's been admitted. And then what you have for the most part, if it's a statement or if it's text messages, then the exhibit itself will speak for itself. If you've highlighted parts of it, the court will probably, in all reality, admit it as an exhibit, but will say that it's not considering what you've highlighted. Technically, the court should not admit anything that you've altered. So if you've admitted something and you put in your own personal highlights on things that you want to focus on, the court is really not supposed to admit those things because they've been altered. It's not a fair and accurate representation of the text messages because those aren't automatically highlighted. So be cautious of that you're not altering any documents by either highlighting them, putting notes in the margins. When I have a case if I've got a pro se opposing party, I will say, I have no objection to the admission of this minus the highlighting and these little notes in the margins and the things like that. And the judges will usually say, yes, we're not admitting those pieces. So those won't come in. Again, they're not facts. They're not statements that the court can consider unless the court admits them in that fashion. So keep in mind when you're doing that, you've got to admit the exhibit itself. Otherwise, the court can't consider it. One of the things that you can talk about when the other party is testifying is you get to do what's called impeachment of them. So if they say something that they're completely lying, you can try and impeach them with information. If you have a document that proves that what they said is not true, you can try and impeach with the actual document. You can impeach them based on credibility from prior felony convictions. Very rarely do you get to use, again, that character of evidence that we've talked about. But generally, the credibility of a witness can be attacked by any party, including the person who's called that witness. And what you're really looking for as far as the ability to attack on impeachment is you get to bring up anything that the court will consider regarding that witness's credibility and how it would explain their motive to say what they're saying, to discredit or shed light on the testimony of that witness. So why are they presenting the evidence? What is their bias? What is their motive? What is their interest? That's where the first thing that you're going to do when Johnny's new girlfriend gets up to testify, you're going to say, well, you're Johnny's new girlfriend and you guys live together and you don't want him to get in trouble. Those are the kind of things that you can talk about by impeaching the credibility of that witness because of their relationship to the person or their bias that they would have to that person. One of the things that also happens a lot in court is you'll be in the middle of testifying and sometimes you've got somebody asking you questions. Sometimes if you're pro se and you're watching this video, you don't have an attorney asking you questions and the judge isn't really supposed to ask you specific questions either. And so you might forget something. And so if you say, Judge, can I look at my notes? And so you can refresh your recollection about things that are out there. But what you cannot do is you cannot take a written statement and read from it. You can look at it and you can basically say what you have memorized from it. And if you say, Judge, can I look at my statement to see if I missed anything? You're allowed to what's called refresh your recollection. But the two things to keep in mind with that is that if you're looking at a document to refresh your recollection, the other party gets to see what you're looking at. The court may ask to see what you're looking at, to see what you're using to refresh your recollection. But if you don't remember something, just say, Judge, I have a text message. Can I look at that real fast to see what date and time that was? If you need to refresh your memory, ask to refresh your memory. That's allowed. And the courts will give you a certain amount of leeway to be able to do some of that. So that covers most of the general admissions for evidence. Now I'd like to talk a little bit about objections. You are able to object to information when it comes in. This handout that I have is evidentiary objections A to Z. So common ones that we're going to see objections for, you're going to object as hearsay. You're going to object for relevance. You're going to object possibly as improper opinion testimony. Under the rules of opinion testimony, you're going to need an expert to come in and testify to many opinions unless they're what's called lay opinions. So you can't have somebody come in and say, I know they were speeding because they were driving really fast. That's more of an expert opinion or somebody who has to have some type of training or experience to get that. So you have all these different types of objections that you have. Argumentative, it's not likely to be sustained, which means it's a valid objection. That's oftentimes going to be overruled, or the attorney or the judge will tell the attorney or the party, ask it a little differently. You don't want to be arguing with the witness. The dynamics of court in general, how you're presenting your case, is the person who started this portion of litigation. So it may not be the plaintiff or the petitioner. If the respondent filed a motion to modify parenting time, the respondent's going to start first. They get to put on their evidence first, all of their witnesses, and the other side gets to cross-examine each one of the witnesses. And then the person who put the witness up gets to testify or gets to ask the last set of questions so they can clarify anything. The opposing party doesn't get what's called recross. They don't get to cross-examine them again unless there's a lot of new information that came up on direct or redirect, which is what it's called. So that's how each witness goes. The person who calls the witness gets to ask questions. The other party gets to cross-examine them, and then the person who called them gets to ask and clarify some of those questions from cross-examination. That goes back and forth until the person who started that portion of litigation is done with their evidence. Then it flips to the other side, and then the other side gets to present their witnesses and their evidence under the same premise. That person calls a witness, they get to ask their questions first. The other side gets to cross-examine that witness. And then the person who called that witness first gets to clarify and ask any other follow-up questions from that cross-examination. And then the court takes into consideration everything that was presented that's using it. So when you're asking questions, or when the other side is asking questions, if you feel that the question is a problem, you get to object. If they're asking the same question the same time, you can say, object, judge, cumulative testimony. We've heard this a million times. It's been asked and answered. We know the answer to this, so you can kind of move things along. A very interesting objection that is used oftentimes when I've got a pro se party is when they're asking a question in a way that it confuses the trier fact. That's an actual objection. It's here, confuses the issues. Under the Rules of Evidence 403, trying to confuse the issues and bring to the trier of fact, usually the judge or a jury, information that they need to know to weigh and to figure it out. So you're going to have, like I said, the hearsay testimony is going to be one of the most relevant objections that you're going to have. Another one that we're going to have a lot of is speculation. So people are not allowed to speculate and say they have to have personal knowledge to what they're testifying to. So if you ask somebody what happened when Johnny went inside, unless they saw what Johnny did when Johnny went into the house, that's speculation. It's either speculation or it assumes facts that are not in evidence. So if Johnny told Mom, I went inside and I got a drink out of the fridge, and Mom says Johnny went inside and got a drink out of the fridge, she either knows that because Johnny told her, which is hearsay, or she is speculating because he came outside with a drink in his hand. So they can't testify to speculative things that they don't know. They have to have personal knowledge, actually saw what happened. The other major basis that we have for evidence objections is we talked about the relevance of the question or relevance of the exhibit itself. Or if they're trying to mislead things, you can object that it's a misleading question. And so just overall objections that are covered from A to Z. Not as few as you usually see on Law and Order or something like that, but the handout gives quite a bit of information on what those objections are and how you use them. Those are the major issues that I think is important for you to know as a pro se litigant coming into court. First of all, the applicability of having at least 3 copies of everything that you're going to hand out, that you have those uploaded well in advance of the hearing for the court. Because what you'll do is if you're having a virtual courtroom hearing, you'll do exactly what I'm doing. So you'll want to practice that. You may have to jump on WebEx and try and share your screen and admit the exhibits as they're coming. Some judges are much more comfortable with WebEx, so they'll pull up your exhibit for you. Other judges will not. So you have to be prepared to maneuver in the WebEx system to be able to present your evidence and present the exhibits. And so those have to be uploaded in advance and things like that and share those screens. But so we've talked about how you admit the exhibit itself, what the decorum of court is, how you admit the exhibit and the items, your copies that you have to have, as well as the overall presentation of evidence and the process that it comes from it. Each time that you're going to have what we call substantive hearing, so final orders hearing, your major hearing, you're also going to have to provide in advance what's called a trial management certificate or a statement of the case, depending on the type of case that you have. If it's a family law, a modification of child custody or things like that, you'll put together a trial management certificate, which lists all of your witnesses as well as what they're going to testify to, what exhibits you're going to admit and what they're numbered as. And then it's an explanation for the court to see in advance of when you go to court what you're asking the court for. So if you're asking the court that I want 50-50, you're going to have a trial management certificate filed at least 7 days in advance saying, here's what I want 50-50, here's why I want it, here's why I think it's the best interest of the children, and here are the witnesses that are going to testify and what they're going to testify about that is going to prove the court I should have 50-50. So you have to admit those kind of documents so that you're prepared to go into court. Most of our judges are going to be very understanding and helpful as far as you're doing as a pro se litigant, but you also need to understand that you have the initial burden of knowing the rules of evidence, knowing how to present the case, knowing what to admit, what not to admit, and knowing that if you don't actually admit the document, then the court can't consider it. So you have to learn a little bit about those pieces before the court can do anything else that it wants to do. Our self-help center is absolutely fabulous on answering any of the questions that you have about some of those logistics. They probably are the ones that referred you to this video in the first place. But if you have some of the questions how to do that, I will reiterate and mention that they cannot give you legal advice. So they can't tell you what to do or how to argue it, but they can make sure that you have the right forms. They can give you some of the handouts that we're talking about, send you to videos and things that we've recorded for training and help with our pro se litigants. But you can also often set up an appointment with them to try and coordinate and work things out with them as well. So that is the evidence information, basically from A to Z on how you present evidence and present your case in court as a pro se litigant. If you have any questions or concerns, I'd say contact our self-help center. They are there to help you.